Hey, everybody, this is Chuck Cook. It's great to be with you today here on our live this week. I'm managing partner here at Cook Baxter, and it is just a joy to talk about immigration with you. Now, what we're going to talk about today is really, really important. This is about the Biden Family Unity Parole Program and what's happening with the stay that is now in place by a federal court judge. What is a stay? What's going on with litigation? So let's talk about that briefly so we can really better understand how this impacts you on your immigration case and on your filing. Now, for those of you who are aware, the PIP program, the Biden Family Unity Parole Program, was designed by President Biden to mimic an existing federal program called Military Parole in Place. Military Parole in Place has been around for a very long time, officially since 2013, but even before that, in 2007, 2008, when the Bush administration decided they needed to do something, one, to keep people coming into the military whose family members were undocumented. And at the time, it allowed people whose spouses were undocumented for them to apply for them, who were to go from being an undocumented person to being a documented person. Basically, parole in place is another word for that is magic fairy dust. In this respect, magic fairy dust is you file this, and if you are a good person and you're not inadmissible in that you're not somebody we want to deport, you don't know felonies, you don't know misdemeanors, you're a good person. They sprinkle dust on you and say you have entered legally. Poof. Why is that important? Because if you entered legally and you have a U.S. citizen spouse or you have U.S. citizen child over the age of 21, you become what's called an immediate relative, which then means you can just apply for a green card in the United States. No waiting period, no having to leave. The Biden Family Unity Program is for those people whose spouses are U.S. citizens and they themselves, as the undocumented person, have been in the United States for 10 years. Now, the thing with this is that you can't have any convictions of any kind. Arrests are going to be held against you. An order of deportation means you probably might not be approved. And so there's a lot of exceptions that kick people out of the program. But they did this because every one of these people can get a green card. This is not like, oh, you're never going to get a green, now you get one. That's amnesty. No, it's not amnesty. Everybody that in this program will be able to get a green card another way. That is, they have to go through what's called a provisional waiver or forgiveness in advance, and then travel to their home country's embassy to get their green card. The problem is that process, that alternative process right now, takes about 4 to 5 years. And for part of that time, the family is going to be separated. These families almost all have small children. They all have kids. They've all been together for a long time. This person that's undocumented in the country for at least a decade. It's just stupid. It's just stupid and a waste of money to make and time. People go through this long process for the same thing we could get them with magic fairy dust. Now, the Parole in Place program itself from the military and Biden Family Unity is based on a statute. The statute is Section 212 D5 of the Immigration Nationality Act. Now, why Section 212 D5 is important is because Section 212 D5 says the president may parole into the United States anybody who's being here is in the national interest, and there's several other criteria that they can have. And basically, the Supreme Court, not that long ago, last year or so, said, look, this is the president's authority. He can do this. It's the authority on which the program for Cubans, Haitians, Nicaraguans, and Venezuelans was based. All right, it's the parole program. And they were paroled into the United States. The military part of this program is they were paroled into a status. They were paroled into an entry. They were admitted into the country. And a court has even ruled to say that's an admission. So that's the Biden parole program. And I don't know how many, 10,000 applied the first week. Several thousand were approved the first week. And many more have filed after the first week, including today. But on Friday night, the state of Texas, in its infinite and glorious wisdom, sued the Biden administration on two principal bases. One, in order to sue the government to stop a program, a state has to show they have something called standing. That means they're affected negatively. They are punished. They're in some way harmed by this federal statute. And their argument is this: it harms us when an individual who is undocumented is given status, is allowed to apply for a green card in the United States and become documented, instead of them leaving the country and coming back in. And you're going, what are you talking about? That's the stupidest thing I've ever heard. How are they possibly injured by somebody not having to leave for X period of time and still getting a green card? They're still going to get it. How are they harmed? How are they harmed? It's a great question. No one knows. They just said it. They didn't present any proof of it. 16 states said these magical words that somehow they're harmed. And the second basis is the use of the word into, I-N-T-O, in the statute. To them means from abroad into the United States. It does not mean from no status into a status. Okay. Even though Congress in 2020 approved how the military parole-in-place program is working. They gave a stamp of approval. Yeah, it's working just fine. According to Congress, the use of the word into is just fine. But that's okay. They ignored that. So they filed this lawsuit, and they filed what's called a TRO, a temporary restraining order. The judge this is assigned to is a Trump-appointed judge. He appointed the very first month Trump was president. Judge, very smart, graduated #1 in his law class from a great law school, UT. He was the same judge, by the way, who worked for the state of Texas against the DACA and DAPA programs. Okay, so he knows these issues. He absolutely knows these issues. Clearly does not have an affinity for immigrants or immigration programs. But you know what? I think he's a fair judge. I don't think he's sworn an oath, to be fair. So what he did was interesting. He didn't grant the TRO. He didn't. And the government did something very, very, very interesting. In response to the TRO, which was filed Wednesday evening, Monday morning, the government filed, or I guess it was, Friday evening, or maybe Saturday morning, the government filed a request for discovery. That is, hey, state, show us how. How are you harmed? We want discovery on standing. This is a very unusual request, but not unusual because the Supreme Court in 3 recent decisions has struck down decisions from Texas judges and their appeals court, the Fifth Circuit, on standing, saying just because you don't like a policy and just because somehow you're affected, this doesn't mean you have standing. Doesn't mean you can sue. So there's 2 types of Supreme Court cases, one saying parole is great, the other saying, look, you don't have standing, that are directly contrary to Texas. Crazy, right? So one of the good judges dismissed the case. Well, it doesn't really work like that. So what the judge did in response is the judge issued a 14-day stay. A 14-day administrative stay in the case. So he's not granting the injunction, but he did grant for 14 days this stay. He's scheduled, interestingly enough, expedited processing on discovery, and also put into place a case schedule in that, hey, we're not going to do motions here. We're going to go right to the heart of the matter. So the administrative stay, which Justice Barrett had talked about as sort of a mystical thing, and I don't really think it exists in the law, that just stops it from going to effect for 14 days. And you have to look at, what minor, it doesn't go to the TRO is you're probably going to win. Administrative stay is I need time to decide this case. All right, so he's got this administrative stay, which is, under the All Writs Act, probably okay. I think it's somewhat mystical, whatever. The judge spends a lot of time talking about the administrative stay. And he says, look, I'm not going to talk about why there's jurisdiction here, and why there's not jurisdiction here, why they're standing, why they're not standing here, though he does spend a significant amount of time talking about that. What he does say, look, I think there should be something that we can move forward on. So he grants the stay, and for 14 days. He then says this: we're going to put this top priority. So the government now has a deadline of today to file any motions related to venue or form. So the court, if I was the government, I'd file a motion to transfer the case to D.C. I would do this in a heartbeat. I don't know if they are. They have to. Why get it out of Texas? Why is it in Texas? Let's get it to D.C. or to Maryland, where probably I would go DHS jurisdiction. Let's get it to D.C. Second, August 30th, Friday, there's a deadline to respond to that motion. And then Monday or Tuesday, there's a deadline to reply to that motion. So that's only if the government decides to file a motion on where this case should be heard, both on the actual location or the judge itself. Maybe get rid of the judge at this point. Then on Friday, there's also a deadline for anybody who wants to intervene. I'm not worried about the intervening. That's kind of not really relevant to what we're talking about today. Then the court says, look, I'm going to give you, government, 21 days to do discovery on this process, and we'll rule promptly on discovery disputes. So the government's going to say, look, show us all the evidence how you're harmed. Show us. Give us the documents, not suppositions, not prepositions, not anything. Tell us exactly how you are harmed. 21 days to discovery responses due within 5 calendar days, the days 31 to 30. So all discovery to be complete by September 16th. So really within the next 3 weeks, all discovery is done. Then the court says, you know what? Let's do summary judgment. So let's go right to the facts of the case. Let's forget the TRO. Let's go right to that. Now, during this time, the judge can lift the stay. He will have to convince the government to agree to a stay. I don't think the government's going to agree to a stay. And we'll talk about what a stay actually means in reality in a second. So he set a summary judgment schedule so they can begin filing by September 26th a motion for a response to request for relief and motion for summary judgment. He then gives October 3rd as the date the plaintiffs can reply to that. And then the defendants get till October 10th, and then they're going to have a hearing. So hearing's going to be, and the decision is going to be right around the election. Maybe the judge is setting this will be election issue. So now that you know what's going on, all right, so the parties are arguing like crazy on this. What does this mean for you as the applicant, as the spouse of an applicant applying for parole in place? One, if you filed during that first week from Monday till Friday and you were not approved, your case cannot be approved. It can be denied. It can be denied, and I suspect many will be denied. It can be decided. That is, they can make the preliminary determination and literally say push a button when it's free to do so. So they can actually do all the work up until approve it. They can request more information. They can do all those things, which means when this case is over and we win, and I'm confident that we will win this ultimately, you'll be approved. Now, the bigger issue is this: what should I apply now? If I haven't applied, I was planning on applying. Should I apply? Well, here's the deal. You have to understand that almost every lawyer is going to tell you the exact same thing. One, we have no idea what's going to happen. We cannot guarantee a result. While I am confident that the government will win in this case, I don't know. You know, I'm not a prophet. I look at the legal arguments. I look based on my legal understanding, my 35 years of experience litigating. I just don't see how the judge, absent doing somersaults and backflips and ultimately getting reversed by the Supreme Court, can say he can't do this program. But other lawyers will disagree. I'm going to say, no, it's dead on the water. Don't do it. So one, you take the risk. You're taking the risk. Now, what is the risk? One, you'll be spending money. You'll spend the government $580. You're paying a lawyer to file your application. If it's over, it's lost. That money's gone. Give the government, the USCIS will not return that money. That's in their regulations. That money's never coming back. So you'll be spending money. One. Two, the other risk. What's the other risk? Well, who's going to win the election? I don't know. That I don't know. If Trump wins, this program's gone. I've said this from the beginning. This program's gone January 21. This program's gone This program is gone January 21 if Trump's elected. We all know that. So the idea was to get people filed, get them adjudicated, get them approved before Trump is elected. You're going to know in about 70 days who won the election. And I really do believe you'll know the same day of the election, the next day. So at that point, if Harris wins, then you file. Okay, then you file and you keep the fight. If you apply now, just understand if the judge denies it or he doesn't reopen, or he puts it on hold, or the Court of Appeals puts it on hold, which is possible if we win at the trial court level, then at the end of the day, it's just sitting there waiting to get adjudicated. Third, what's the third thing that could happen? Well, the government has your information. So can they use that information against you? Sure they could. Will they? Maybe, maybe not. Who knows? They didn't use it against DACA kids. I mean, they had all the DACA kids information. I'm not sure they'll use it for this. But again, you as the applicant are taking the risk. The lawyer's not taking the risk of filing these cases. You are. So you have to decide what you want to do. We have a lot of clients who just say, damn the whole thing, we'll move ahead. Now, if you have at the same time, and many people do, they have a parole in place. With your parole in place filing, they have the provisional waiver pending. And we got 2 provisional waivers approval today. It's just great. So they're still doing the provisional waivers. And let's see this case on hold for 6 months and your provisional waiver gets approved, go to the consulate. Okay, you've lost money, but you haven't lost anything else. Almost anybody who applies for this program has provisional waiver available to them. So what's the worst case scenario? You have to do a provisional waiver. So basically you're just gambling money that you're going to get provisional waiver faster than you're going to get parole in place faster than you will a provisional waiver. That's what you're gambling here. That's it. Now, there are people applying for parole in place who aren't eligible for the provisional waiver, and that will be people who have a permanent bar. And that's because immigration said in the regulations, plain and clearly, look, if you left the country, briefly during the 10 years, that's okay. That's called a brief, casual, innocent departure. But if you left the country, they don't mention this, but if you left the country during those 10 years and you came back, without a visa, you have a permanent bar. So they're clearly going to approve people, maybe. I mean, who knows? But the logic says yes. Approve people who have a permanent bar. Okay, you won't be able to get this. So now the government will have your information. All right. Is that any worse than they have now? People that have an uneffectuated removal order, you can apply. They already know you're here. You're on their list, right? So how are you affected? You're not. You're just paying money. So like I said, you can keep filing these. You can hold off till after the election to see who won. You can hold off until the case is over. The reality is if Harris wins the election and this case takes 2 years, this program's coming back. Right? So it's still going to be there. But only you can decide how you want to do this. But you make sure your lawyer is telling you all the facts. We have a handout. We give it to people. We say, I want you to read and sign this. You understand all the consequences of doing this. And the upside, of course, is the program comes back and they approve you. And now you can get a green card in the United States. So there are all those things. So that's the Biden Family Unity Program. I'll probably do one later tonight in Spanish, so to help my Spanish colleagues. Let's take some questions here. This is Bernard. It's always on here early. Bernard, good to see you. Hey, Iona is always on here for me. Concerned citizen, nor to deny any person to be protection of the law. Yeah, well, I don't think they really care about that. Republicans love bureaucracy. Actually, I think they do. Keith Ferrani, would you make a video on policy manual for national non-immigrant student visa updated September 20? Keith, I think I'll do that. Thank you very much for the great idea. I would do that. What is your opinion of the judge? I don't know the judge. He's clearly a smart guy. He clearly worked against DACA and DAPA, but that was his job working for the state of Texas. He's a member of the Federalist Society, which is a very conservative group of lawyers. The reality is he might be the worst possible judge for us. But I remain steadfast in believing that almost every federal judge, almost everyone, there's a couple that I don't do this, but most of it is fair. They swore an oath. And I take them at their word until they show me they can't be trusted. That's all I can do. Ellie, my husband was arrested when he was 17. Was processed as an adult because of his birthday the year after he turned 18. Trust me. Yes, if he is arrested, there's a whole thing you have to go through to see if you can apply. But it's going to be very, very tough. Even though charges were dismissed, the criteria are very, very strict. But we need to see the charge. I'm going to punish America. Well, there you go. I applied, Marijon Pedraza. I applied for the first day and went to get my bad records done today. Frozen DACA work permit. Oh my God. You have both of these? You have a frozen DACA and a frozen parole in place. No, you will not need to redo your work permit. Okay? No, the DACA, if you applied for DACA work permit, that's only for DACA. So once approved for the parole in place, yes, you will have to apply for a new work permit. But why? Just apply for a green card. And your work permit comes with that. So don't just randomly apply for a work permit. If you get parole in place, you only have one entry, you just apply to adjust status. And with that, you apply for a work permit. And a lot of people are getting their green cards before they even get their work permits. Who is giving advice to these states? Satan himself, Stephen Miller, is giving advice to these people. Yes, Satan himself. And he's not a lawyer, by the way. Not a lawyer. I submitted my parole in place Monday. For the judge submitted for 14 days. I checked my status today because received, notice not sent. Receipt notice. You'll get the receipt notice. Just taking them time to generate receipt notices. You're fine with that. Lots of attorneys think it's a good judge are saying how these people apply for it. I think that's a stupid idea. I think that's a stupid idea, Jalen. I don't know who lots of attorneys are, but they're stupid to think that a judge getting letters is in any way helpful. It's not. It's not helpful at all. Don't do that. Bad idea. Does the lawsuit only apply to parole in place? No, it's just parole in place. There's a separate lawsuit on the current DACAs. They're fine. You just keep getting your work permits. Do you see Department releasing updated visa bulletin, the announcement that they should all? Well, I thought they issued it. I thought the September visa bulletin said that they had issued everything. As far as I know, they've issued that. So, I mean, maybe I'm wrong. I'll have to go back and take a look at the visa bulletin. But let's just take a look at the visa bulletin right now. The visa bulletin September says that final action dates are still available. Yeah, I imagine they will send out an updated chart. At least they used to when Charlie was in charge. 2020 cases on appeal. Amen, Jocelyn. Este tío es un bestia de abogado. Gracias, Noel. Exactly. Okay, Ben, how many actually got approved the first week? I understand from sources that several thousand got approved. Several thousand got approved. I would imagine that anywhere from 10 to 30,000 got filed. I mean, the system shut down at one point. So I know they got 10 or 20, 30,000, several thousand got done. That wouldn't surprise me at all. How long is it taking for 601A waiver right now? 26. It's about, if you look at, you can check these yourself on uscis.gov. You go to uscis.gov and you go to check processing times, and you just put the word 601 in, and you click the waivers of random disability in Nebraska, and it will tell you that right now it's taking 28 months. So you've got 2 more months. They just keep getting longer. The system is broken. When of those, I don't know, Ben. Nobody knows who was. Only people who are approved can tell you who was approved. Marty, thank you. What about people with misdemeanor for reckless driving? Reckless driving is a traffic offense. That's not, you can apply for parole in place with that. Will advanced parole be at risk for us to use the pathway US? No risk. If you have DACA, get your advanced parole, travel, 0 risk. Every single person on DACA who's traveled on advanced parole has come back. The stories you hear about people who stay longer than their advanced parole is authorized, or who get robbed and lose their advanced parole, and even they come back eventually. So you're fine. If you've got DACA, I'm begging you, do an advanced parole if you don't have a legal entry. You never know what love holds in the future or when your child will turn 21. We're doing a lot of green cards for parents that have DACA for kids who are 21 years old. Yes, we are. Satan himself. I applied and got notice and sent me biometrics. I already had, so you're good. DUI in 17, DUI, nothing. You can't, you 601A approved, yeah. So EB 135, you can't do parole in place. You have a DUI. You're barred. So do your Mexican appointment in Mexico. You will be fine. You will come back on your green card. I don't know when your 601A was approved, but right now it's 8 to 12 months for appointment in Juarez. Why are some deadlines? The deadline to apply is September 9th. Some lawyers, Marlene? What idiot is saying? I just read you the order. You can just keep applying. There's no deadline to apply. It just doesn't exist. Who knows? Just because you get a JD and pass the bar doesn't mean you're a good lawyer. Can we schedule an appointment with you for a consult? Yes, of course you can schedule an appointment. We do tons of Zoom appointments. All you got to do is call here, 404-816-8611. I love doing that voice. Call for a consult today. You can also go to our website, immigration.net. Up at the very top, you can schedule an appointment right up top to come see us. So let's go back to the Family Unity Parole Program. Get some more comments here. Let's see. Seen anything on parole in place with an order of removal? No, I haven't seen any about. I don't know. We haven't had any of ours order of removal that are approved. Can my husband apply for PIP if he actually removal order at the border in 2004? Yes. I'm sorry. No, he cannot. He has a removal order. If you haven't, and he has an executed, that's an executed removal order, so he cannot. Barred. Will they schedule biometrics for those who need it? Well, they're still doing biometrics, yes, and they should, but they haven't announced it yet. Hopefully later today, they'll announce exactly what they're doing. All the judge told them was you cannot approve any. If they have brains, they will be adjudicating them, taking the money, adjudicating them, doing everything, and then just holding them. That's what if they have brains. But nobody accused immigration of having brains. I have an approved I-130, 618 pending, F-130 pending, EAD expired. Anything I can do to get EAD? Well, what's your EAD? Oh, EAD was based on a pleading file that was closed. Yeah, no, you're SOL, Richard. No, if your case was closed, then you've got nothing. You're going to lose your EAD. So sorry. Letty, ¿cómo es el proceso para indocumentados con título universitario in Biden program? Somebody's asking about the 212D3 waiver. Letty, yo hice un video hace como 2 o 3 semanas vía mi página de YouTube y ahí está el video acerca de este programa. I just told her to go to my YouTube page. I did a video on this about what that means. Why are they giving A numbers to PIP applicants? Because they're creating an immigration file. Whenever they create an immigration file, they get an A number. Period. End of story. What do you think we'll have to after 14 days? Great question, Melissa. I'm going to guess they're going to extend it, is my guess. It's going to extend it for 14 days. A lot will depend on what the government gets in discovery. If the government's going to move on Friday, and maybe the judge says you're right. They don't have standing. They have nothing. It's a big nothing burger what they have. Or maybe he moves it to a different venue. Who knows? So, but more than likely it'll be extended, is my guess. My OBIM FOIA only returned DACA. OBIM FOIA shouldn't return. Return DACA. Yeah, okay. Today, what about return to Mexico? My good. If you were detained and returned and you didn't have fake documents, that's a voluntary return, and your VR probably says that VR. Yeah, if you get advanced parole, you can adjust status absolutely. But I want to see the OBIM FOIA results. You should leave your contact information on the whole time on the screen. Oh, all right. Maybe I should do that. That's a great idea. It's a great idea, Iris. Yeah, great idea. Remember, I'll now go back over here. Here it is. Here's my contact information. 404-816-8611. My email, anybody can email me. I answer every email I get. So you can email that. You can also follow us on the Twitter machine. And por supuesto, si habla español, aquí estamos en español. And our website's super easy. It's immigration.net. How much easier does it have to be than immigration.net? All right. Jalen, God forbid if you were to cancel this program, do you think people who already applied would at least get a response? No, they'll just say thank you for the money and have a nice day, is what they'll say. Let's see. Eddie, my aunt's from El Salvador has DACA, but doesn't have family here. Her husband's from Ecuador. She apply. Yeah, go see your family. Absolutely. She can also go to a conference. She can go for dental work. There's lots of reasons you can travel. It doesn't have to go see family. Me puedo poner en proceso de deportación. Yo tengo los requisitos para proceso de cancelación. Sería Biden. Lady, no hay modo de ponerse en deportación. She asked if she can put herself into deportation to apply for cancellation for removal. Right now, there's not a way to do that. There's not a legal way to do that anyway. Although I hear tell that they're thinking about that plan as well to allow you to put yourself into deportation and apply for cancellation removal. I think it's a terrible idea because only 4,000 cancellations can be approved a single year. I mean, I think it's a terrible idea, but especially since we know that the results of the election. And Richard Zunio is our last question. The judge mentioned the issue of the stay. These states have merit. Based on this, it's very likely to extend the stay. No, I think you're right. I think you probably will extend the stay. But it depends on what the government says in response. I mean, the government hasn't responded yet. Wait for the government, he says, yeah, they have merit. But there's been a lot of Supreme Court cases since he went to work on DACA. And I will tell you, the complaint is garbage. It's garbage. And they're going to respond with what garbage it truly is. So I think they're probably going to extend it, as I said, but hopefully I'm surprised. That's what I hope. All right, everybody, it's been great to be with you. I'm probably going to come back this evening and do a live en español. But esta noche voy a hacer un live en español como a las 7, 8, algo así. But if you guys have any questions, you just call right here. You can call me for a consult. You can email me your questions. Happy to answer any questions you happen to have. And, of course, you can DM me on the Twitter machine here. Until I'll see you tonight in Spanish, but next Wednesday I will see you live at 1 o'clock. We'll see you then. Oh, one more question here. One more question. Oh, Richard just says thank you. Thank you, Richard. You guys have a great week. We'll see